Good morning, everybody. We resume then with our proceedings, and as you know, we will commence today with leading evidence, or leading Mr. Mrwebi's evidence. Good morning, Mr. Mrwebi. Ms. Manda, can you kindly administer the oath?
Please state your full names for the purpose of the record.
Sithembiso Lawrance Mrwebi.
Will you take an oath or affirmation?
An oath, madam.
Do you swear that the evidence that you shall give shall be the truth, the whole truth, and nothing but the truth? If so, raise your right hand and say, "So help me God."
So help me God. Thank you. Let me concentrate at this side first. Let me concentrate at this side first. Yeah.
Thank you. Mr. Rip?
Thank you, ma'am. Advocate Mrwebi, could we have a look at your curriculum vitae just when we started for those who want it? It's in folder D 6.1 of the Dropbox. Could you tell us with reference to that? Well, I think I'll just take you through it because I don't think there's a dispute. You completed a BUris degree from the University of Fort Hare in 1981, is that correct? You must just switch it on.
Correct, Chairperson.
Perfect.
Sorry.
Didn't know you had such a big voice. Thank you.
Also surprised, Chairperson.
And then you commenced employment on the 28th of January 1982 with the then Ciskei Department of Justice as a prosecutor at the Alice Magistrates Court.
That is correct, Chairperson.
In 84 to 86, you were appointed and served as an assistant magistrate in the same court and dealt with civil and criminal matters.
That is correct, Chairperson.
And in 1986, you completed your LLB degree, at which time you were appointed the regional court prosecutor for the regional division of Ciskei, which position you occupied until early 1989.
Correct, Chairperson.
During 1989, you were appointed as an assistant state legal advisor in the Department of Justice, Ciskei, which position you occupied until the mid-1991.
That's quite correct, Chairperson.
And during that tenure, you were responsible for rendering legal advice and opinions, as well as drafting of legislation for government departments.
That's correct, Chairperson.
In 1991, you joined the then Office of the Attorney General, Ciskei, as a senior state advocate, which position you occupied until 1998.
Quite correct, Chairperson.
And during 1998, you were appointed in terms of Section 15(1)A and B of the National Prosecuting Authority Act as a Deputy Director of Public Prosecutions in the then Office for Serious Economic Offences, known as OSEO, in Pretoria.
Quite correct, Chairperson.
In that position, you dealt with the investigation and prosecution of serious economic offences.
Quite correct, Chairperson.
Okay, during 2001, OSEO was merged with OSEO, which had become the Investigative Directorate for Serious Economic Offences, merged with the then Investigative Directorate for Organised Crime to form the Directorate for Special Operations, also known as the Scorpions.
Correct.
And in 2002, you were appointed as the regional head of the Scorpions in KwaZulu-Natal.
Quite correct, Chairperson.
Could you just take us through a little bit of what your position involved at that stage in 2002? Do you have your CV with you?
Let me just look for it. You mean in KZN?
Yes, while you were head of... In 2002, I just wanted you to take us shortly through what your position as regional head of the Scorpions in KwaZulu-Natal from 2002 involved. It's in paragraph, it's in the curriculum vitae. It's on page 1. At the bottom of the page, the last paragraph. Just expand a bit on what that role involved.
Chairperson, as the regional head of the Scorpions in KwaZulu-Natal, I was in charge of the regional office in the province of KwaZulu-Natal, basically managing the
Mr.
office.
Mrwebi, sorry, what happened? You're doing so well.
I have a tendency of surprising myself, Chairperson, all the time. In KwaZulu-Natal, I was in charge of the regional office and responsible for the investigation, prosecution of serious organized crime, investigation and prosecution of serious complex commercial crimes, and I was in charge of an office with about a staff of about, at the time, it was about 105 people at the time.
Okay, and while you occupied that position, you also retained your position as a Deputy Director of Public Prosecution.
Quite correct, Chairperson.
Okay, so when the Scorpions was eventually disbanded in 2009, what happened with you then?
In 2009, after the Scorpions was disbanded, we were told that we need to decide as the former members of the Scorpions where we would wish to be placed. And my choice was to come back to Pretoria where I started, and I started I was placed at the office of the Director of Public Prosecutions in Pretoria.
And what were you responsible for there at the Director of Public Prosecutions at that time?
At the time, at the office of the Director of Public Prosecutions, I was in charge of a unit called the Special Prosecutions Division, which was a unit basically composed of a number of different specialities, like your commercial crime, your environmental crimes, your tax unit, and your sexual offenses unit. Very disparate units.
Okay, and that position you occupied until on the 1st of November 2011 in terms of the proclamation. You were appointed as a Special Director of Public Prosecutions and head of the NPA Special Commercial Crime Unit.
That's quite correct, Chairperson.
And that position you hold till today?
I hold that position until today.
Sorry, can I disturb you again? You then go too close and you have an echo of sorts. I don't know whether it doesn't disturb you. So you speak loud, but not necessarily into the mic, if you know what I mean. Yeah.
Thank you, Mr. Mrwebi. Then you will have heard the evidence that was given by certain individuals, and some individuals were critical of certain of your activities. For instance, there was evidence that in 2006 there was a problem with you when you were still the head of the Scorpions in Natal, or KwaZulu-Natal, and that there was prospects of disciplinary steps being taken against you or even a possible transfer to Pretoria. Could you perhaps just take us through what the events were surrounding the activities of yourself at that time?
Chairperson, it's a very, very long story.
I think just try and summarize it.
And I would try to summarize as much as possible. And say I occupied the position as the head of the Scorpions in KwaZulu-Natal from 2002. And we have been doing well as an office in terms of our overall mandate. 2003 as well, we were doing well. The actual or the real problem started in 2003, 2004. In terms of government policy, in terms of performance management, you are being assessed on an annual basis in line with the financial year of government, which is the 31st of March of each year. In 2003 financial year, I had my assessment. I had my assessment done for 2003-2004 financial year. It was then done by my then supervisor, who was stationed here at head office. And in terms of the scoring for performance, to say whether you are performing, you are either satisfactory, or you are a poor performer, or you are average performer, an above average performer. So there are types of scores that they give you. I was assessed, I think it was about April 2004, and my scoring as determined by my supervisor was 67%. I was obviously dissatisfied with that score, because judging from my performance and taking into account the resource constraints within the office, I felt it was unfair, because I believe that in terms of what we achieve, because we have targets in terms of performance, in terms of convictions, in terms of various types of convictions. So I believe that I did more than I was given, but that was fine. I said.
Can I interrupt you for a moment? Who was your supervisor that did this evaluation?
Chairperson, I'm not comfortable to name my supervisor for obvious reasons.
Okay, I can continue with your story.
Or for reasons, not for obvious reasons.
Oh, okay.
For reasons that I rather not disclose to the commission unless I'm told to do so in camera or for you know.
But is that information not public? It's an
That
assessment
information
by a
is not
supervisor.
public, but
everybody knows who your supervisor is.
Yes, and that information is contained in the document, I think, which is in the drop.
No, the information about who the supervisor is.
Yes, because I don't want the temptation.
It's contained in the drop.
Yes, I don't want to. I want to avoid the temptation when I
Fair
go
enough.
further and continue dragging
Talking
his
about the
name.
supervisor.
Yes.
So, for now, it's fair enough.
Yes, Chairperson. So the point is that that was fine. I accepted the score. I said that's fine. But what happened in the course of time, you know, in the Scorpions, we had what we called confidential funds, like your Secret Service account of the crime intelligence, for example, where in our situation, we would pay informants for the information that they give us for reporting crime incidents relating to offenses within our mandate. we got a directive sometime before the end of the financial year in March 2004. The directive was from our head office to say all the regional heads of the DSO must make sure that all their informants that they have in their books who have not been paid for their services must be paid. And I was comfortable that from my office in KwaZulu-Natal, yes, we do have informants, but at the point in time, we did not have the informant that had to be paid any fees. The directive was given that there was a particular case that was referred from head office to my office, and the informant in that case, according to head office, must be paid. I said, no ways. From the information we have in our books, that person, yes, indeed, was of good help in one of our investigations, but we have discontinued any idea of paying him, because as he was helping us in this investigation, we discovered that he was actually on the side continuing the crimes that he has reported, to the extent by that time he has already been sentenced to a term of imprisonment. That's the long and short story of it. So we don't have a person to pay. But I was pestered that according to head office, a person must be paid, to the extent I was called upon to prepare a document in respect of that particular project.
Advocate Mrwebi, perhaps if I can just interrupt you. The whole story we don't believe is relevant, but what was the end result? You did an investigation as to the use of C funds, and what was the conclusion, the end result of your investigation?
Yes, the end result, in fact, my suspicions were raised after it was insisted that I must prepare that document and an amount must be stated that a person was to be paid. Then my suspicions were indeed a person was paid, and a person who had nothing to do with the investigation, and that person had nothing to do with the investigation, and the people who were implicated were people at our head office in Pretoria. So the investigation actually led to the fact that we're able to point to the actual suspect who stole, or rather who were involved in these irregularities relating to the payment of this informant. So
you filed a report to the head office about the irregularities relating to what you call the confidential funds by certain senior management in Pretoria and in the DSO.
Yes, I filed a report based on my investigations, and I also alerted at the time the acting national director at the time. Unfortunately, that is when my problems in the DSO started.
So what was the reaction to this report? What did you start experiencing, and what was the consequences of you making this report to the head office?
After making this report to head office, the attitude of management changed towards me. I was starting to be accused of non-performance. All of a sudden, I was accused of non-performance. I said, but guys, how can that be? We are still in almost 6 months into the new year. I've been assessed just in April. How now do you come up and say, I am suddenly this poor performer? Things started to change. And then I became a target of all sorts of victimization, and instructions were given that I am going to be removed from the office because my management of the office is not good, and all that kind of stuff. I would be given instruction to vacate the office by a certain date. I would be given instructions to choose any office in the NPA. If I don't do that, I would be dismissed. literally, my life became, starting from, as a result of that report, my life became a living hell, to the extent that did not only affect me, it affected my family as well.
Okay, and so when these statements were made by Willie Hofmeyer and I think McAdam, that there were these reports that you hadn't done your work properly, obviously those are the reports they would have heard at Red Office following upon these incidents.
Come again.
I said, so when Mr. Hofmeyer and Mr. McAdam and some of the other witnesses said they understood you weren't performing well in KwaZulu-Natal, the true story is that there was a vendetta against you by officials who were embarrassed by your report.
Absolutely. You know, the point is, I said, guys, you are accusing me of all these things. You know that in government or anywhere else, there are laws, labor laws in this country. If somebody is accused of having done anything, there are processes. I challenge, or rather, I offer myself. Take me through those processes and prove whatever you are alleged to. The point is that no allegation has been put. What are these areas of non-performance? What are these areas of concern? Nobody ever came to say to me, what are these areas of concern? I challenged them. I challenged all the time. I am being instructed to vacate the office because the management is no longer happy with my performance. But up to the point, up to a certain point, no action was taken. No.
So no disciplinary process
No.
was ever instituted against you in respect of these allegations?
No disciplinary process was ever taken against me for this process until I decided at some point in 2006. Now, when the allegations in 2006, allegations changed now from poor performance to say they are going to investigate me for the very same allegations in relation to the irregularity of the confidential funds. So a new allegation came. Until then, in 2007, I decided to lodge a formal grievance process. And then I also went through to the bargaining council to lodge a complaint of protected disclosure because I felt I was being victimized for having done a protected disclosure, you know.
Okay. Advocate Mrwebi, can we just stop there for a moment? There's a bundle that was prepared. I'm not sure if, hopefully you have got a copy. It's the bundle we gave to you this morning.
Yeah.
Have you given it? Well, sorry, my attorney will hand you a bundle. There's a bundle prepared for each of the panel and for Madam Chair, this bundle is also in the Dropbox, but because of our difficulties with the Dropbox, we prefer working with real paper and actual documents. So, ma'am, if I could take you to the bundle, you'll see the very last flag on the bundle is called Labour Matter Referral. And it's headed Annexure to Conciliation Form, Nature of Dispute.
Now, before we interrogate that document, let's just confirm, Mr. Mrwebi, are you saying all these directives and allegations of non-performance came from national office or the National Director of Public Prosecutions at the time? Is that what you're saying?
They came from my direct supervisor,
Direct supervisor.
also from the acting national director at the time.
Yeah, I think that's all. Thank you.
Thank you, ma'am.
Continue.
So, this is the document you referred to. You referred after taking years of abuse, you eventually went to the Labour Court or to the CCMA, I believe, and you've got two disputes there that you have referred at the top of that page. Nature of dispute: the first dispute relates to occupational detriment in contravention of Protected Disclosure Act 26 of 2000. And then you say the facts and circumstances surrounding the disputes are of a continuing nature as the unfair labour practice is continuing to date. And then you deal with a number of attempts to resolve the matter were made, and you start off in 2004 and take it all the way through to 2007 financial year.
That is correct, Chairperson.
And this document then covers the period over which you just gave evidence to the tribunal or to the panel.
That is the position, Chairperson.
I'm not going to take you through the document, but the document itself sets out in more detail the general evidence you've given, and you confirm that the evidence or statements in your document are correct.
Quite correct, Chairperson.
Okay, so now we have a position where at the end of 2007 there is a pending labour dispute between you and the NPA.
That is correct, Chairperson.
The next event that a number of witnesses made much of, in particular Mr. Hofmeyer, was the application by then National Commissioner of Police, Mr. Celebi, in January 2008, when he wanted a stay of his prosecution. You recall that evidence?
I recall that evidence, Chairperson.
And one of the big issues that Mr. Hofmeyer in particular had was that he continuously accused you of interfering in the prosecution of Mr. Celebi and in fact attempting to help Mr. Celebi fight off the prosecution. Do you recall that evidence?
I recall that evidence, Chairperson.
And the main purpose of that, or the main basis of that, was an affidavit that had been made by yourself in July 2007.
That's correct, Chairperson.
Could you just take us through this affidavit and how it came to be made?
The sequence of events relating to this affidavit, Chairperson, are the following. Sometime in May 2007, a document known as the Browse Mole document appeared in the press in the country. This document was alleged to have been produced by the Scorpions, or the members of the DSO. The document alleged that the then former president, who was the deputy president at the time, Mr. Jacob Zuma, was involved in a kind of conspiracy involving foreign governments, being assisted by Gaddafi of Libya, Dos Santos of Mozambique, to topple the country. And this document alleged other serious acts that were being committed by those who were involved in the conspiracy to topple the government at the time. I read about this document in the news media in Durban as well, where I stayed. On the 5th, or a day before that, it must have been the 4th of June, we received a call from head office. By that time, Mr. Piccoli was the national director. We were called to an urgent meeting to head office Pretoria, head office of the NPA. We were not told what the reason for the meeting was. Only when we arrived at the meeting, Mr. Piccoli, who looked visibly angry, told us that something that the government is seriously concerned about, that is sort of putting the government in a serious, in a difficult position. This document that has been leaked into the media and it is alleged this document was produced by the Scorpions. So the purpose of the meeting is to find out from us whether, as the heads of offices in the various provinces, we know about this document. He asked each one of us, and in my case, from KZN, I told him, like everybody else, I read about the document in the media, and others told their stories, but the important thing was that Mr. Piccoli told us that the government is seriously concerned about this, to the extent the President Mbeki at the time has instructed that an investigation at the highest level be conducted. The National Security Council task team was appointed to do the investigation to find out how this document came to be. What are the sources, what are the intentions of the creators of that document? The instruction at the end of the meeting was that each one of you is required to cooperate with the investigation. Indeed, I was happy after that because I don't have any relationship with the document, so I don't have anything to worry to contribute to the document. I went back to my office in Durban.
Sorry, Alex, before you go back to the office in Durban, who all attended this meeting? You referred to numerous people and heads. Do I understand you correctly that the head of every region in South Africa from the DSO attended this meeting?
That is quite correct, Chairperson. Mr. Piccoli, the National Director of Public Prosecution, the head of the Scorpions, Mr. McCarthy, the acting head then of the operations, as they call it, the investigating director, Mr. Mngwengwe, and all the regional heads of the Scorpions in all provinces were there as well. They used to have what you call divisions in the DSO, you know, crime, we call it CAD, Crime Affairs Division, or something like that. Crime Analysis Division. There were other divisions, your operational support division. So the heads of those units, all the senior people were there in that meeting.
Okay, so it was a substantial meeting.
It was a substantial meeting, yes.
Okay, so now you went back to Durban?
I went back to Durban.
What happened next? Were you approached by the task team that you spoke about?
Yeah, I went back to Durban. Let me just interpose and say, in the meantime, by the 18th of June 2007, we remember there was a policy conference of the ANC that took place. It was which was a normal thing. We were not concerned about that. It didn't bother us until some time later on. One of the resolutions that were taken in that conference was that was a resolution to disband the Scorpions. You know, it didn't bother us because it's their business to make policy and to decide on things. Now, on the 24th, we received urgent call to come back to head office, 24th of July, 2007, to a special DSO meeting. We were not told what the agenda of the meeting was. Instruction was just come down. You will hear when you come. Indeed, it was a special meeting chaired by the head of the DSO at the time, Mr. McCarthy, and all the senior officials who were in that previous meeting I mentioned were present. The discussion of the meeting was about the concerns that management has about the decisions of the policy conference which took place on the 18th of June. We had a discussion around that because some of us were, why should we be concerned? I think let's rather put our case, let's rather do our research. We should not be entering into that space, you know. But it became very clear that this notion that it is that the Scorpions or the DSO would be disbanded was causing a lot of unhappiness, a lot of panic among the members. Then, in the course of the meeting, after a number of discussions of other things, it was decided that there are basically 4 matters that are the concern that the DSO is concerned about, that we need to take a decision either way before the ANC conference in Polokwane in 2007. it was a concern for us. Why should we get into that space in the first place? We don't have to influence anybody. We just have to do our work. But in any event, it looked like there was a genuine concern that we have to do something. So there were 4 cases that were mentioned at the time. The cases that were mentioned, number 1 is the Zuma case at the time. We know the Zuma case that is currently before court now, if I'm correct. And the second case was the case of Mek Maharaj. The second case was a case of Ramatlodi. The 4th case was a case called BG project, Bad Guys project. At the time, I did not know what the project was about until I got information later on. The problem with all this information was that they were telling us about cases we have no knowledge about, because these cases are managed at head office. We don't have any role. We don't have any contribution in their direction, in their investigation, one way or another. I wondered what contribution was expected from me. But I was told, these cases are very important for the survival of the DSO. We must take a decision either way. That was strange. How would these cases determine the survival of the DSO? But we were told that those cases are very important, are key cases. After some further discussions, then the meeting ended, and the head of the DSO told us that he is going to send each one of us an action plan in terms of what needs to be done in relation to those cases. Then after the meeting, we went back to Durban. That was the end. That was July 2025, July 2007. I went back to Durban after that meeting. For August, nothing happened. Round about I do not recall the exact date, but it could have been towards the end of August or beginning of September 2007. I received a call from a person who identified himself as a member of the investigation task team that Advocate Piccoli told us about, that it was going to investigate the origins of the Browse Mole document. The gentleman, I don't know whether he was the secretary of the national, but he had to do with the National Security Council itself, which was located in the office of the president at the time, President Mbeki. The members of the investigation task team want to visit you in Durban. I said, in connection with what? No, in connection with the Browse investigation. I said, what
was the investigation going to be about?
That was
the origins of the report, the Browse Mole report, or the source of the leak of the report?
Chairperson, according to the terms of reference of that investigation, it's just that because I don't have access to my documents, I recall that we received the terms of reference of that investigators team that was investigating. But amongst the terms of reference, it was going to investigate the sources and the origins of that document, the intentions of the compilers of that document, amongst others. So it had its own terms of reference. So I got this call to say I must expect a visit from the members of the investigating task team. I said, but why? Because I told Mr. Piccoli during our meeting on the 5th of June, I have, like anybody else, I read this thing in the paper, I have nothing to contribute to the investigation. And the gentleman told me that he will be contacted. Indeed, a member from I think it was from National Security at the time, NIA, contacted me and said they want to come to Durban, and I also asked them the same question. He says, in the course of their investigation, they discovered some information that might need answers from me. So they want to contact me about that. I said, fine, you can come. Then on a particular date, I cannot recall, but it was in September, they came to Durban. Gentleman from NIA, gentleman from crime intelligence at the time, and I think there was somebody from the presidency and also somebody from crime intelligence in Durban. So we went to a place of a meeting. They told me that we are continuing with our investigation of the browse mole document as instructed by the presidency as part of the task team of the National Security Council. Then I told them, guys, but I have nothing to contribute here. He says, no, wait. We are going to tell you the information that we gathered from our investigation was that the document emanates from your office. I don't know whether I went pink or white or red, but I just was shocked. And then I was told the circumstances, how it came about. The long and short of it. Now when they outlined the circumstances, because we were also in our way dealing with informers, we get information from a number of people. I remember that in 2006, I reported a matter to the National Intelligence Agency, which emanated from a report from somebody who was reporting a certain crime to us. And that report, it was an ordinary criminal, a certain person we known in the criminal world, more especially in the white-collar criminal world, who was the known who gave information to us. We said this information is meaningless. Maybe people from crime intelligence or national intelligence agency can make use of, we referred him to that, but we advised our head office about in 2006. It appears that it was the basis of that information that the head of the DSO, as I later understood, said the document emanated from my office. I denied that. I was requested to look into our database and find out what sort of information have we received since a particular time, 2006, and who are the informants who were in our books and all that, and then I must do that investigation and assist them. I did that. I went through all our informants registers, records and everything, and compiled a document, which was a kind of a report to say, in a sense, to dispute the fact that any information relating to the browse mole document was ever given by any of our registered informants or sources. So I compiled that report and gave that report to the members of the National Security Council task team. Then that was my report. It must have been the middle of September 2007. I gave them my report. I thought that was the end of my story with them.
Sorry, Advocate Mrwebi. The report, is that the document of the 27th of September that was later attached to Mr. Celebi's application?
Let me finalize to say.
Okay.
Let me finalize to say. Again, soon thereafter, it must have been a week or so, I got another call to say the members of the investigating task team are coming back to my office to verify certain information. Then I said, fine, you can come. Because I knew I did not have any information. But this time it was a bit awkward because when they came to me, they confronted me about the meeting of the 25th of July, the meeting of the DSO where we discussed those cases. But my temptation initially was to deny. But when they laid the basis, I said, if I deny, I'm going to be in trouble here. It's clear these people have original information. So I decided, yes, sir, that is correct. That was the meeting. And then I was together. But I asked a question to them, if I recall. But what has this got to do with the Browse Mole investigation? But I recall telling me that in terms of their mandate, in terms of their terms, these kinds of things, because it's kind of showing that we are acting outside our mandate and things like that. But they gave me an answer. But the long and short of it, they requested me to depose to an affidavit. Important thing is that I was advised and told that this is a top secret investigation. All information is treated with utmost secrecy. It will not be disclosed to anybody at any. So it was on that comfort that I decided, let me depose to this affidavit, because I knew nobody will ever know about it. On the 27th of September 2007, that is the affidavit. And that is the affidavit that was attached to Mr. Celebi's court papers.
After you deposed to that affidavit, to whom did you give the affidavit?
After deposing to the affidavit, I gave it to the members of the task team who visited me in Durban.
Did you ever give it to anyone else?
I did not even keep a copy for myself. I made that one and gave only that original one. I did not even have a copy with me. I did not give any document to anybody else at the time.
Okay, then the next time you heard about this affidavit was when you read about an event in the newspapers in January 2008. Is that correct?
Yes, that is correct. Chairperson, in January 2008, I cannot remember this particular day, but I don't know whether I got a call that I must read the Star newspaper. I had to hunt for the newspaper because I think at that time in Durban, the Star newspaper was not very everywhere. So I had to go and look for the newspaper. I saw a front page article to say, Mrwebi, Celebi's last hope. Those were the headlines. I was very, very angry. I phoned one of the members from crime intelligence, from head office, who visited me in particular, to say, gentlemen, what is happening? How did my affidavit landed in the hands of other people, yet you told me that this was a top secret investigation? I was assured that the document was declassified. There was a request even to the president himself because of whatever reasons. And I was assured that there were also discussions with the then Minister of Justice, so I should not be afraid. All processes to declassify, to deal with that document were followed. So I should not be concerned about that. But I accepted, although I was not happy.
Fine. Did you, obviously I think you've answered the question already, but just for clarification purposes, did you ever discuss the application by Mr. Celebi for the stay of his prosecution with him or any member of his team or anyone prior to the application being launched and you learning about it in the newspaper?
Not at all, because I did not even know Mr. Celebi or anybody close to him. I knew Celebi like everybody who sees him on TV, you read about him in the newspapers. I never discussed anything with him.
So you never have had a conversation with Mr. Celebi, you've never met him, you've never spent time with him?
That is quite correct, Chairperson.
Excepting for one occasion when you obviously at the court case itself later.
Except on one occasion where I had to testify in his criminal court case sometime in 2010, yes.
Okay, now the next thing that happened after this event was that you were approached by someone from the head office, if I'm not mistaken, Mr. Mngwenwe, or Advocate Mngwenwe. This is now in January 2008.
Quite correct, Chairperson. It must have been early 2008, around about, but it was before the end of January 2008, when Mr. Mngwengwe contacted me to say I must offer an explanation to him as my supervisor why I gave my affidavit to Mr. Celebi. And indeed, I explained the circumstances like I did from the start of this, my involvement with the Browse investigation and how I was approached. I gave him the fullest explanation to say, at the end, I was assured that this was a top secret investigation, and I do not know and I cannot explain how my document ended in Mr. Celebi. I think the best people who could explain that would be the members of the National Security Council task team, and I gave him names to say, please go and talk to these people so that you understand the exact position. I don't know whether he did that, because sometime it must have been towards the end of January, I received a notice of suspension. Yes, I think it was a notice of suspension. No. Either I was put on special leave. I think it was a special leave.
Yes, in fact, you were put on special leave.
Mr. Rib, before you proceed with your next question, let me just get some clarity. When you testified at the Celebi trial, what was your testimony about? What did it relate to?
Yes. Chairperson, I have not yet testified now by 2008.
I thought you said you testified.
Yes, at some point I did testify. I was still going to come to that piece of evidence because it follows after this. Yes.
Madam, we're trying to more or less follow chronological
understand.
story, but if you wish to
No, let's
clarify
wait
it at
until
this
then.
stage,
Then it will fall into place.
as it pleases the tribunal.
Thank you.
So on the 27th of January, you were in fact placed on special leave by the then acting National Director of Public Prosecutions, Advocate Mshe.
That is correct, Chairperson.
And what was the basis of the complaint that the head office had with you? What was the grievance with what you had done?
One of the complaints was that I disclosed NPA information without being authorized. Thus, I contravened Section 41(6) of the NPA Act. That was one of the allegations against me in relation to the information that was in the possession of Celebi, in relation to the meeting of the 25th of July 2007.
And in fact, they proceeded to institute disciplinary steps against you?
That is correct, Chairperson.
And even laid criminal charges against you?
I might not be sure about the criminal charges.
Not at that stage?
Not at that stage. What I know is that they instituted a disciplinary hearing against me, and that when that disciplinary hearing was due to start, I lodged an unfair labor practice action in the labor court, trying to interdict the NPA on the grounds that what I did was a protected disclosure in terms of the Protected Disclosures Act of 2000. Unfortunately, I lost that application because I had lodged my papers in the bargaining council. Then I also, when they started with the disciplinary, I lodged that interdict because there was that pending bargaining council protected disclosure proceedings. Then I approached the labor court to say for an interdict because there was this pending. I lost that application because by the time the labor court decided the matter, the bargaining council had already determined that it does not have jurisdiction in terms of the Protected Disclosures Act. So I rather approached the labor court itself. Thereafter, I immediately again launched another application in the Labour Court to interdict the NPA on the grounds that I was being victimized for having made a protected disclosure in terms of the relevant Protected Disclosure Act.
And that application led to an interim order by Judge Kelly.
That application led to the interim order by Justice Cele sometime in 2009.
And what happened to the disciplinary hearing?
As a result of that, the NPA entered into a settlement agreement with us, with me, and no further, with the understanding that it was a confidential agreement in terms of which we are going to drop any proceedings that each has got against the other. The NPA would drop any action. I would also drop any actions that I had against the NPA. And we entered into that agreement, and which was signed between myself and Advocate Mshe on behalf of the NPA. And because it was negotiated between myself and Advocate Mshe of the NPA, was the acting national director at the time.
Yes, and Mr. Willie Hofmeyer, during his evidence, made the statement that in that settlement, the NPA wasn't a party to the settlement and, in fact, knew nothing about it. I never quite understood how he got there, but he seemed to indicate that as far as he was concerned, the National Prosecuting Authority wasn't a party to the settlement. What's your comment on that?
Mr. Hofmeyer would not know anything, and because he was not party to the negotiations between myself and Advocate Mshe. I never interacted with him during that process. He would not know that, I don't know where he gets the information that the NPA is not party.
And then you were reinstated, or your special leave came to an end after this agreement.
Yes, that is correct. My special leave came to an end after this agreement.
Okay, the next significant date is, in fact, the Celebi trial. As indicated, you gave evidence at the Celebi trial. How did it happen that you gave evidence at the trial?
By that time, I was already within the office of the Director of Public Prosecutions in Pretoria as the head of this unit, Special Prosecution Division. I knew that the case of Celebi was proceeding. And at some point, Mr. Simelane was the national director at the time. At some point, the sheriff of the court came to the office of the DPP in Pretoria to serve me with a subpoena to attend proceedings in the case of Celebi, to go and give evidence. The subpoena was signed by the registrar of the High Court. I also tried to, yes, I determined that it was a lawful issued subpoena and the persons who were served it were lawfully entitled to do so. Immediately after that, I think through my, Mr. Mzinyati was my supervisor at the time. I think through him, I spoke to Mr. Simelane to say, I received this subpoena. But at some point, I did speak to Mr. Simelane directly, that I received this subpoena. I am very uncomfortable with this. This is the NPA that is prosecuting. Although I don't know the nature of my evidence that I was going to, because it was not stated, it was just a subpoena to give evidence in the matter of Celebi. I did not know the nature of the evidence, but I was not very comfortable. Mr. Simelane says, "Sir, you must understand that this is a court order. This is in the nature of a court order. You have no way to disregard unless we can go to court and apply for it to be set aside. For now, it's a court order. You either comply or you are committed for contempt of court." Then I decided, let me rather go. It was only when I went to that trial that, when I was in the witness stand, that I knew that I was going to testify about this affidavit, because I did not even consult with Celebi's lawyer. I did not even consult with Gerinel, who was the prosecutor in that. I was just called to the stand. I only knew when I was in the stand that I was going to testify about that affidavit.
So by implication, you weren't aware that the subpoena was going to be served on you. It wasn't done by an arrangement between you and Celebi's legal representatives?
No, Chairperson, it was not done through Celebi's legal representatives.
And that was the occasion on which you met Mr. Celebi actually at the trial, the first time and only time.
That was the first time I came closer to Mr. Celebi in my entire career, or in his career as the National Commissioner of Police.
And then I believe it was Advocate Jaap Celebi SC who then asked you questions at the trial.
It was Advocate Jaap Celebi who led me, during the trial, asked me questions, yes.
And it related to the same affidavit?
Related to the same affidavit, and I relayed the circumstances as I did before this inquiry, how it came about, up to the point to say my understanding was that this was a top secret document investigation, and this document was also top secret. I have no clue how Mr. Celebi or anybody came to be in possession of that affidavit.
The Judge Joffe, who was the presiding judge, also eventually found Mr. Celebi guilty on certain of the charges and gave a lengthy judgment of some 289 pages. And he refers in passing to your evidence as well in this regard.
Yes, amongst the things that after going through my affidavit, the Justice Joffe also mentions the fact that, he understands, I understood this document to have been a top secret document. It appears that somebody got hold of it for whatever reason and made it aware and made it available to Mr. Celebi.
Madam Chair, that document, the full judgment has been placed in the Dropbox. We're not going to refer to specific pages, but it is there in folder J, I believe.
Yes, we have it.
And thank you, ma'am. Ma'am, could we at this time perhaps take a short break? I think we'll stick to Mr. Aronson's comfort break. 5 minutes, if we may.
I think we have been alerted to the need to do that within the hour every time. Ne? Yeah.
Thank you,
Thank you. We will adjourn until the next hour. Can you take 10 minutes? Thank you, everybody. We're continuing with Mr. Mrwebi's leading evidence. Mr. Rip.
Thank you, ma'am. Advocate Mrwebi, just on the Celebi, just to wrap that up, you've referred to the report of September, you've referred to it quite a number of times as top secret. The content thereof, can you confirm the correctness of that? Just deal with what was in the affidavit itself?
Yes, Chairperson, I confirm the correctness of the contents of that report, of that statement.
Now, I'm just going to go back a little bit in time because we moved on the Celebi matter. In 2008, January, another event occurred, which was the arrest of Advocate Gerry Nel.
Yes, I heard about that, yes.
So, and Mr. Hofmeyer in particular seemed to have got himself very involved with that and made allegations against you as well relating to that arrest. Were you a party to arranging his arrest or in any way making it conducive for his arrest?
Chairperson, by that time I was in Durban. I had no role of any nature whatsoever in relation to Mr. Nels' arrest.
There was an affidavit from you or statement by you in the docket. Do you recall that?
Yes, Chairperson, I recall that at some point in time I was requested to make a statement in relation to that matter.
Who requested you to make such a statement?
I do not know what they call him, brigadier or colonel at the time. I remember receiving a call from somebody who referred to himself as Mr. Mabula at the time to say that he will come to Durban. He wants to meet with me because they have got an investigation that involves a member of the DSO, and there are some issues that he wanted to clarify with me by way of a statement. And then I said, that's fine. If there is a lawful investigation, I cannot refuse to help you. That's okay, if I will be able to.
So this is Mr. Mamabola?
This is Mr. Mabula.
Mabula.
Yeah.
So Mr. Mabula was a member of the police services?
Yes, I understand him to be a member. Yes, he was a member of the police. Yeah, he was a colonel. I don't know his position at it. I can't recall his position, to be honest.
And as a result of his request and his visit, you made the statement that was in the docket?
Yes, when he visited, he told me the nature of the investigation and why they required a statement from me. And the statement mainly was about procedural issues in relation to how the DSO, manages their investigation from institution up to investigation. It was to explain the process or procedure of instituting investigations in the DSO.
Other than that, you had no involvement whatsoever with Advocate Gerry Nels' arrest or any subsequent events to him?
Sorry, that is correct, Chairperson.
Madam Chair, the statement is in the Dropbox. It was sent through, one of the documents that was sent through in the last few days. I think it is in the Dropbox. Can we just check on that? I thought I'd emailed it through to, but we'll get back to that when we got an opportunity, ma'am. But
Yeah, it seems Ms. Bauer is shaking her head. I don't know what that means. We don't have it in the Dropbox, not yet. Can you kindly ensure that it?
I thought it
gets
was sent through, but we'll just clarify that and deal with it a bit later. I just want to identify the document.
Yes, thank you.
Thank you, ma'am. So now we go on from 2010, which is when you gave evidence in the Celebi matter, to 2014. It doesn't appear to have been any, Mr. Hoffman didn't find anything to accuse you of in those 4 years. In 2014, the OECD matter came up, in which Mr. McAdam gave evidence about. Do you recall that?
Yes, I do, Chairperson.
And just to remind, that's the foreign bribery matter.
That is correct, Chairperson.
Now, Mr. McAdam's evidence related to a period from the end of 2014 to 2015 when he was involved as the general, we never quite worked out what his role exactly was, but he was like the supervisor or general manager of the OECD reporting activities would appear at least. Do you recall that evidence?
Yes, I do, Chairperson.
Now, his evidence was extremely critical of a number of aspects. He felt that he seemed to leave behind the impression that nothing was being done, that you as head of the SCCU, he seemed to have a particular gripe that not enough was being done about bribery cases because of the nature of the commercial, it was a commercial, serious commercial crime and the like. Do you recall that evidence?
I do, Chairperson.
Now, we are still a member of the OECD. That is, South Africa is still a member of the OECD.
South Africa is not a member of the OECD. South Africa is a member of the OECD Working Group on Foreign Bribery.
And if you have a look at the document, the bundle in front of you, you'll find, well, it's the second last document, Madam Chair. Should be marked 2018 OECD report. It's got a black page in front which says Transparency International Exporting Corruption. I don't know if you can find that document, Madam Chair. It is also in the Dropbox. I think it's in volume J. Do you have the document, ma'am?
Give us the reference of the document. We don't have the Dropbox here.
I don't have the but it's in the bundle that we gave you. I actually don't know what the Dropbox reference is. I think it's volume J, but I don't know the exact number of it.
Yeah.
It's in the cloud, ma'am.
Yeah. Drop at some stage.
Is it the 2018 progress
Yes.
report?
That's correct, ma'am.
Madam Chair, we will
Yeah,
not
we have
object to the hearsay nature of the very document that Advocate Rip had objected to when I sought to raise it.
I know.
We're all friends here, ma'am.
After all.
I learn slowly, ma'am.
Expecting corruption. Yeah. Yeah. The document.
But let's deal with the very document. This document, which my learned friend is aware of, is a document prepared by an independent organization called Transparency International. You see that,
Yeah.
Mr. Mrwebi?
Yes, Chairperson, I see that.
And it's it calls itself a Progress Report 2018 assessing enforcement of the OECD Anti-Bribery Convention. Do you have that?
Yes, I see that, Chairperson. Sorry, I see that, Chairperson.
Okay, now, yeah, the criticisms from Mr. McAdam and Mr. Hofmeyer appear to be that under your leadership, it would essentially appear South Africa had been left in dire straits relating to its position within the OECD and its activities. You recall that?
I do, Chairperson.
And this document makes quite interesting reading. If we could take, ma'am, to page 12 of the document, you'll find there's a heading, Status of Enforcement, next to the capital A. And I'm just going to read in to the record what it states there and ask your comment. It says, since the 2015 report, 12 countries have moved to different bans. 8 accounting for 7.1% of world exports have improved, while 4 accounting for 6.7% of world exports have deteriorated. The 2 biggest improvers are Israel, from little or no enforcement to active enforcement, and Brazil, from little or no enforcement to moderate enforcement. Israel's increase is due to the successful conclusion of its first ever foreign bribery case in the form of a settlement, and a significant increase in the number of opened investigations. In Brazil, it is largely due to the successful conclusion of a major foreign bribery case by means of a settlement. So, Mr. Mrwebi, it appears from this that Israel and Brazil have now, by 2018, managed to complete 1 foreign bribery case.
That is the position, and I know it to be the case because I sit in the OECD working group on foreign bribery.
So then it goes on to state Norway and Italy have moved from moderate enforcement to active enforcement, while Sweden and Portugal have moved from limited enforcement to moderate enforcement. And then it goes down the page to at the bottom, active enforcement, 7 countries with 27% of world exports: the United States, Germany, UK, Italy, Switzerland, Norway, and Israel. Moderate enforcement of 4 countries with Australia, Brazil, Sweden, and Portugal. Limited enforcement 11 countries: France, the Netherlands, Canada, Austria, Hungary, South Africa, Chile, Greece, Argentina, New Zealand, and Lithuania. And then 18 countries of little or no enforcement, which includes Japan, South Korea, Spain, Mexico, Russia, Belgium, Ireland, Poland, Turkey, Denmark, Czech Republic, Luxembourg, Slovak Republic, Finland, Colombia, Slovenia, Bulgaria, and Estonia, to which they also add China, Hong Kong, India, and Singapore. So what is your comment about where South Africa finds itself in the overall scheme of things, considering what I've just read out?
Sorry, Chairperson, let me comment about the position of South Africa. By 2015, South Africa was in the area of no enforcement, limited or no enforcement. In October 2018, just before my suspension, I made a presentation in Paris to the OECD. At the time I made that presentation, it was at the time that it was said South Africa was in a perilous state of being subjected to what in the OECD is called a 3bis. 3bis is a provision in the recommendations of the OECD relating to the fact that if the country concerned does not improve in its enforcement of foreign bribery offense, a delegation comes from the OECD to visit the country, do a physical inspection, and thereafter issue a report that has devastating consequences to the country, because that report is accessible to the rating agency, to the lending institutions. It affects the standing of the country financially. That was the position in 2015. But when I presented my report in October in Paris, By the time I did that, one of the most important things, or rather let me say, Chairperson, one of the criticisms that South Africa has always been receiving from the OECD working group was the fact that our investigations as far as foreign bribery is concerned do not progress beyond the preliminary stage of investigation. We always report all the time, we are doing preliminary investigation. So that was the concern. But by the time we reported, let me give credit to my colleagues, Advocate Baloy in the NPA, Brigadier Basi of the Hawks, General Mosipi of the Hawks. They did a wonderful work. By the time we reported at the OECD, we had a number of active investigations that have progressed beyond preliminary. To the extent as we reported at the time, we had 12 investigations that have proceeded beyond preliminary stage to becoming active full investigations. So that was a commendable success for South Africa. And very, very importantly, as you hear from this report, Israel concluded one of its investigations by way of a settlement. We reported to the OECD in October that we have initiated an investigation in relation to another matter. So that moved the country a bit a notch forward. At least that is why we avoided that criticism that we were supposed to be subjected to. Because by the time I reported at the OECD, that matter was not in court yet because of the problem that the accused in the matter absconded at the time, at the point of arrest. So we were hoping that within the next 2 months, we'd be able to have the matter before court. So as soon as that matter is before court, I'm sure we will overtake a number of countries. South Africa is in the league of countries that are doing not so good, but there's something that is being done. We're not doing bad compared to major countries that are part of the OECD. So in a sense, South Africa, the allegation in the evidence of Mr. McAdam, based on objective evidence. Unfortunately, I don't have the report. If I had the report, because I don't have access to my documents, I would be presenting the report of the OECD that I presented in Paris and the result of that report.
Sorry, can I just get clarity? You currently are giving us evidence on the 2018 report. Is it possible for us to have the report at the time at which, say, McAdam was reporting during that period? Because if I look at the status that's provided here, there is an indication of some movements, whatnot, in respect of other countries, but I don't see anything that talks to where South Africa moved from. I hear what you've testified to, that there was a movement as between the time that McAdam left and when you presented that there were certain significant improvements. But do we have anything that, you know, objectively as in the same league as maybe this kind of a report, from where we can glean that from?
The question is a bit difficult for me because I'm suspended. I don't have access to official documents, so it's only the NPA that can help on that.
But Mr. Advocate Mrwebi, just to perhaps assist the panel, the purpose of what we're trying to show here is that Mr. McAdam and Mr. Hofmeyr left behind the impression that South Africa, after McAdam left in 2014, South Africa under your leadership was heading to a certain disaster, that it was an unmitigated mess, and that nothing could save it whilst you were anywhere near the OECD. And does this report support such contention by those witnesses?
It does not support their contention.
As far as prosecutions are concerned, you say South Africa was on the verge of instituting a prosecution, has in fact drawn up a charge sheet and the like.
There is a current charge sheet that we're talking about in that particular matter.
And also, because of the complexity of the matters, are they easy to investigate? Do they take time, resources?
You see, the problem with foreign bribery investigations is not only your local investigations. You rely on the evidence from other countries. You have to engage in mutual legal assistance request. You have to, those processes themselves take not only months, but they take years to complete. So it's not an easy thing to do.
Now, if I could take you to page 18 of that same document, it's in section D under the heading of Status of Legal Framework and Enforcement Systems. Page 18. Do you see that?
Status of legal yes.
That page. There it starts off dealing with, at the bottom of the page, bottom right-hand corner of the page, inadequacies. See that?
Yes, Chairperson.
So there they talk about the problems that, for instance, the definition of the offence remains problematic in several countries, including Greece, Portugal, Slovenia, and Russia. And New Zealand and the United States are amongst the countries that continue to accept the legality of facilitation payments, and Australia accepts the facilitation payments defence. Do you see that? Right at the bottom of page 18 in the corner.
Yes, Chairperson.
And then on the top of the next page, anti-money laundering frameworks and systems remain inadequate in many countries, including Australia, Luxembourg, Switzerland, and Turkey. And importantly, relating to the problems, if you go down the fourth paragraph there, they're not numbered, but it starts with the headings, in countries including Belgium, Estonia, Greece, and Italy, an inadequate statute of limitations is a problem. In Italy, despite new legislation increasing the length of the statute of limitations, the fact that limitations have effect throughout all three judicial stages, first instance, appeal, and final, means that final judgments are often not reached within the permitted time frame. Hungary's 2-year time limit for investigations may prove too short for large and complex foreign bribery cases. You see that?
Yes, I see that, Chairperson.
Does that support your contention that these matters take many years to resolve and need substantial time?
That is quite correct, Chairperson.
Then there's a criticism of South Africa underneath that. A significant number of parties to the convention face challenges in the enforcement and systems in Greece, Japan, Slovenia, South Africa, and Spain. Experts report a lack of coordination and communication between different enforcement bodies.
I note that.
And then, apart from criticism of us, inadequate resources or training of police, prosecution of judiciary reported to be a problem in numerous countries, including Belgium, Finland, Greece, Hungary, Italy, Japan, Mexico, Norway, Portugal, Slovakia, South Africa, Spain, Turkey, and the United Kingdom. So we seem to be in quite good company there, even though it's a problem.
Yes, Chairperson. And if I may just add, one of the presentation, as I was presenting my report to the OECD, I think we received a good commendation with regard to our training program, because we presented not only the fact that we are training, we also presented actual evidence of who we are training as far as OECD offense or foreign bribery offense is concerned.
So this report was actually brought out in 2018, before you done the final, this report you're referring about to the OECD in October 2018.
Quite correct.
So what is your feeling about the future of our OECD abilities and what's being done in foreign bribery cases, or any of the criticisms against yourself and us in South Africa in general fair and valid as at 2018, 2019?
As at 2018, 2019, I think any criticism, Chairperson, is, as I heard, it is unfortunate and as it is unfair. Because objective evidence points to the contrary.
Yes, in fact, just to assist the panel, in that bundle, if you go to the bundle that we've prepared there, the document isn't flagged, but it's the second document. It's got the heading Phase 3 Evaluation of South Africa Draft Written Follow-up Report. See that document?
Yes, Chairperson, I see the report.
Who prepared this document?
Chairperson, this report is prepared in the following fashion. The Department of Public Service and Administration is the lead organization with regard to the OECD matters. So they attend to all the logistical arrangements in terms of preparation of reports that must go to the OECD or that must go to the ministers concerned. This report was prepared, therefore, by the department officials who are dealing with OECD work in the Department of Public Service and Administration. This was a report prepared for the presentation to the October meeting in Paris in 2018.
To say South Africa is not a member of the OECD, but is part of
the working group. Is a member of the working group.
It's a member of the working group, but not a member of the mother body.
It's not a member of the mother body. There's a mother body, which is the OECD itself. Then, then there is a working group
of the OECD.
South Africa only belongs to that way. I think it's the 40, if I'm correct, 40, there are 44, 43 members currently. It's one of the 43 members in that group. OECD itself as a body is a separate body. Then there is a working group. South Africa is not a member of the OECD, but a member of the working group itself.
Constituent OECD, whatever. Is it countries?
Yeah, I think it's countries. I'm not sure. If we could go.
And how? Sorry,
ma'am.
Pardon me.
Not at all.
Just for the last time. And how often do countries report? Do they report annually, those countries that belong to the working group? Do they report annually to this working group or over what periods of time?
The reporting is quarterly, Chairperson, 4 times a year.
Okay, thank you.
In that same document, if you go to page 4 of it, the heading consent orders, and then over the page they deal with some of the sentencing pertaining to the issue of legal entities. Then we get to, in the past, March 2016, South Africa referred to the J.A. Brown case as an example. In 2014, accused J.A. Brown received a non-custodial sentence, having been convicted of an extremely serious pyramid scheme where pension funds were defrauded. NPA appealed against the sentence imposed, and the appeal court imposed an effective 15 years direct imprisonment. Do you see that?
Yes, Chairperson, I see that.
The rationale of the court was the wealthy accused should not be permitted to buy their way out of going to jail. And then in addition to the J. Brown matter, reference was made to the case of S versus Ditla Kanyani and others, racketeering charges, total of 9 million, and the 12 accused were collectively sentenced to 1,680 years in prison.
I say that, Chairperson.
What do you say about the allegation that almost no one goes to prison for serious offences?
You know,
Mr. Hofmeyer.
I was very surprised, because if you look at our cases from 2012 up to at least 2016, we recorded a number of convictions with custodial sentences. And just recently, if one reads the press, one of the cases we recorded a conviction of 24 years. And in the cases 2014, 2015, I know that there were custodial sentences of up to 20 years in our cases. So it's just that maybe Mr. Hofmeyer is not aware of those matters.
Who actually runs those trials and agrees to the sentences or not sentences? Are you directly involved in each and every matter happening in each high court?
Not at all, Chairperson, because the prosecutor concerns is the person in charge of each case. He decides on the strategy, the prosecution strategy, and he decides if maybe, I'm sorry, Chairperson. He or she decides on the prosecution strategy. If there's going to be a plea and sentence agreement, he will discuss that with his or her regional head in the region. So I am not involved in at any point in time with regard to the sentences.
Yeah. Perhaps we just refer to the prosecutor. Who does the prosecutor report to? They've got their own head in each division.
The prosecutors in the SCCU report to their regional head. Each one reports to their regional head. It's only, I don't have anything to do with with operational work of the region, unless maybe there is an intervention that is required from my office.
Live visuals there coming from the Mokgoro Commission of Inquiry into the
norm.
That is an exception, Chairperson.
And obviously to run lengthy corruption and serious economic offences trials are very costly for the state as well.
Indeed, Chairperson.
At this point, we did try and, Madam Chair, we brought with a copy of the spreadsheet, but somehow the printers don't want to cooperate with us. So if possible, we'll put it up on the screen, Madam Chair, and we could lead the evidence from there. We will give you copies of what we have, but it's not complete because they're spreadsheets. They go over many pages, and somehow we don't seem to manage to print it exactly correctly. Can you see that, Advocate Mrwebi, what's on the screen?
Not at all, Chairperson. Let me rather look at the laptop.
Okay, look at the laptop. You'll see that the spreadsheet at the bottom has got a number of tabs where there are different years written. Do you see that?
That is correct, Chairperson.
So the spreadsheet actually has about, I think, 6 different reports in the document.
Correct, Chairperson.
If you open each one of those, it will show you the accused, how many there are, what they were accused of, the type of offence, comments on the case, and the sentencing, and in some instances, most instances, the date, excepting in the early ones. Do you see all of that?
That's correct, Chairperson.
Does this also confirm what you've been saying in respect of the type of cases that have been going to court and that you're getting convictions on?
Sorry.
The spreadsheet that we're looking at now, does that confirm what you've been saying about convictions and the type of matters that are being dealt with and finalized?
Indeed, Chairperson.
Do you know if this is a complete list? Because obviously you don't have access to all your documents, but where does this document come from, just to place it in context?
Chairperson, this document would be a document prepared in my office. We normally prepare this document for the purposes of our monthly report, because every month we get statistics from the regions. We compile them in spreadsheets sometimes or in a narrative form sometimes, but this document is a document that would have been prepared under my supervision to the extent that up to 2016 at least.
Sorry, Mr. Rib.
Ma'am.
I'm looking at this statistic, and because you must accept that because it's half-half or whatever, one doesn't get a complete picture. But it seems to me there are a lot of wholly suspended sentences here. I only see one where the person is going to serve a prison term. Nearly the ones that I've just looked at are wholly suspended. Would I be correct in saying that?
Ma'am, there are
Let him answer, please. I was just asking him a question. Let him.
sorry, you're not asking me.
Chairperson, I'm not so sure which document you are looking at, but
The one on the screen.
but
right now.
yes, we do have suspended sentences, but it's not in all cases. But we do have suspended sentences. Indeed, we do.
See, ma'am, perhaps if I could be of assistance, I know Mr. Mrwebi can't actually see what's on the screen. His eyesight isn't good enough. But there are 6 different reports, and what you're looking at is just one page of one of those reports. So in the printed one we've got here, I can hand it up to you. 1 April 2013 to 31 March 2014. The first person got 15 years imprisonment. The next one got 10 years suspended. The second one was also suspended. The next one was acquitted. The next one got 25 years imprisonment. The next one got 3 years correctional supervision. The next one got 43 years imprisonment.
Mr. Rib, I'm sure we're going to have to sort it out because what we're looking at here and what you're reading don't seem to align. Shall we sort it out later?
Yes, ma'am, but then the problem is, as I said, we have to open the correct tab on the document.
That's the difficulty. So as you read, I'm trying to see which one you're reading, and I'm not. So maybe what we should
I'll
do,
hand it up to you, ma'am.
we will, yeah.
I think we'll just hand up to you hard copies as best as we can do it, because the only way to follow the whole document is to open each one of those tabs, and then on the screen it's not showing the entire. It's now been it's been expanded so we can read it, so it cuts off half the spreadsheet. That's a problem.
And you could perhaps also have cited the number of the column, which gives information. But then again, it only gives part of the information. You were reading out column E, which indicates the convictions and sentences. In fact, the sentences.
It's under the heading sentence, ma'am.
Yeah, it's the sentences.
Yes.
Column E. Okay. But we have the document. We can read it. And I think you've made your point.
Thank you. Then, Advocate Mrwebi, we've tried now to follow that train. Can we start on a new subject, and that is your appointment as the Chief of the Special Commercial Crimes Unit, with effect from the 1st of November 2011. You recall that?
Yes, Chairperson, I was appointed as the head of the Specialized Commercial Crime. My appointment letter from the Ministry of Justice is dated the 1st of November 2011. And the Gazette that assigns powers, duties and functions, I think it's dated 25th of November 2011.
Okay, now this is a period of some controversy between some people. You, in the early days of your appointment, received representations from the attorneys representing General Mdluli.
That is correct, Chairperson. I did receive those representations at that time. If I may just mention that I started working at the head office, must have been in the first week of November 2011. And I have received a number of other work issues that I had to deal with. It's not that I was not doing anything before I received. The first thing I did was to receive these. I've been doing other work as well, and during that time.
So after the receipt of the representations, what did you do? What was the next thing that you did in respect of the representations now?
Chairperson, the normal process for dealing with representations, once you receive representations, so that you are able to respond to those representations, you request a report from the prosecutor or prosecutors concerned, and not only a report, but you also you request a copy of the docket. Normally, you have to indicate in your request that the report must address the evidence, its quality, the nature of the evidence, any legal issues that are involved in the matter, and any other issues that he or she may think are relevant to the matter. I did that, requested the office of the Ms. Breitenbach, Advocate Breitenbach, to give me a report. I also submitted to them the copy to say I have received these representations. Submit a copy of the report.
I wonder if we can do something about the heavy blow into the mic. We know we asked you to speak into the mic and speak up. Can you try to manage it in a way that doesn't make that blowing sound? Can you assist kindly?
Yeah. Hopefully.
Thank you.
Is that okay, Chairperson?
No, I can't hear
Let's
you.
hear.
Slightly.
I think leave it where the technician placed it. Let's
Yes.
try it that way.
Yes, I forwarded that request to Advocate Breitenbach together with a copy to request a copy of the docket and the report.
And did you receive reports in the docket?
Chairperson, in my history as a prosecutor, as the head of the Scorpion, as with the OZO, with everybody else, it was the first time that I felt that I was not being respected because I did not receive the report.
And what occurred next?
What occurred next was that I had to write a reminder to say I have requested the report. But what was also strange, because the response came after a reminder, what was also strange with that response after the reminder is that it did not address the matter. It did not address the evidence. It was a kind of report or a response, rather, that was to say, point by point, we cannot entertain this, we cannot entertain this, we cannot entertain this, but it was not telling me what and why and what are the reasons. It was a report that, in a sense, that was not helpful to me. With the result that I wrote again to say I require, because the docket was not submitted by that time as well, where I required a proper report together with a copy of the docket. And thereafter it was provided sometime later on.
Obviously, you considered the docket and all the documentation and reports that you'd received.
I read the docket. The report of the prosecutors was not helping me in anything in the decision of the matter. I read the docket because this time they gave me the docket. That is the document that I read from page to page, every document which was in the docket that was submitted to me.
And as we know now, you formulated the view that the matter was not ready to be prosecuted. In your belief, there was not sufficient evidence at that time to move forward.
Indeed, Chairperson, here is a matter of very simple facts, very basic facts. It's a matter concerning allegations of fraud and corruption. The fraud is in relation to a 90,000 rand shortfall in the car of Mdluli, Mr. General Mdluli. It is alleged that this shortfall was financed in the following fashion. One amount was a 50,000 loan from Atlantis Nissan. The second amount was in respect of the sale of 2 BMWs. One of the immediate things reading through the docket, all these transactions were not done by Mr. Mdluli or General Mdluli. These transactions were done by somebody else. I went through the docket to find evidence, maybe to link Mdluli to say maybe he was part of this. There was no such evidence in the docket. There was, even though these transactions were done by Mr. Barnett, who was the co-accused of Mr. Mdluli, there was no evidence in the docket to say Mr. Mdluli had knowledge of these transactions. The question is, what evidence is there in the docket to suggest that there's a case against Mdluli at the time? So those were just the basic facts, without even going to the allegation of corruption.
And what did you do as a result of the opinion that you formulated and just described to the panel?
Chairperson, let me say this. Before I took a decision in this matter, I went to see Mr. Mzinyati. On the 5th was a Monday. The 5th was a Monday. On a Monday in the morning between 9 and 10, I visited Mr. Mzinyati's office. In my view, I was consulting him. In my view, I was doing that as a courtesy in any event because of the knowledge of the fact that I've been with the NPA. Consultation was never done in the NPA as far as I knew. So I felt, at least let me do the consultation the way I thought was sufficient at the point in time. I went to Mr. Mzinyati to tell him that, Mr. Mzinyati, I am busy with this matter of Mdluli. Indeed, we did not discuss the matter in great detail, but I remember that we did have reference to the facts just by way of background. As Mzinyati has testified, that our discussions took it was close to an hour, 45 minutes. We had spent that much of time discussing the matter, and indeed I told him that I am still doing some research in the matter, further research, which I was hoping to finish before the end of the day, the day I left his office. I did that indeed. After I came back, I prepared my document, which I referred to as a consultative document. In a sense, I was recording the fact that I consulted Mzinyati as I did. And then thereafter, I recall that I also drafted a letter to the lawyers of Mr. Mdluli. I cannot recall when it was sent, but I sent the document to Mr. Mzinyati. I must have sent it in the afternoon of the 5th of December 2011. The reason I did that was a simple one, is because before or soon after my arrival in the SCCU, after some discussions with my supervisor then, Ms. Dr. Ramaite, and also discussions with the former National Director, after it was decided that I must re-establish the reporting lines between the SCCU regional heads and the SCCU office, to the extent one of my visits, or 3 visits, before I took the decision in the Mdluli matter, was a visit to Cape Town regional office, a visit to Port Elizabeth regional office, and a visit to East London. Now on the 5th, I recall I was going to be away almost the whole week, because the next batch of visits was going to be a visit to the regional office of the SCCU in Durban. It was also going to be a regional visit of the SCCU in Bloemfontein. So I felt that let me do the work that I was supposed to do before I leave. So I sent those documents to Mzinyati, the consultative note, and thereafter I think I'm not so sure here, but I must have requested my PA at the time to ensure that the letter to the lawyers was also processed or delivered or sent.
Now, the consultative note you prepared yourself.
I prepared the consultative note myself because it arose from the docket I read, from the research I made, and all those things.
Yes, and I've learned that you can actually type quite well during our time together. So did you type that document yourself?
I type my documents most of the time myself. Yes, I did type that document myself.
Now, there's been a lot of criticism against you and conjecture that because the document was dated the 4th of December, that document was prepared on the 4th, and therefore before you'd even seen Mzinyati, and that you'd actually committed a big fraud on the NPA, so to speak. Can you deal with the date issue for us, please?
Chairperson, I think I have explained this thing many a times, but let me explain it like this. And I think this is the error, this is the error I think we continue to make. When you create a document, if you don't have a letterhead, sometimes you take a letterhead from an existing document, then you remove certain information that is not relevant. Sometimes it happens that you forget to remove all the information. That is how that document was created. But another thing that I may add maybe is this. The 4th was a Sunday. I was not at work on Sunday. So no work or no document could have been sent to somebody on a Sunday. And the error in that date of the 4th was because of how this document was used as a pro forma for the letters and other documents that I was supposed to prepare.
So evidence is it was prepared after your meeting with Mzinyati on the 5th of December.
My consultative note, as if you read the first paragraph, it was to record the fact that I have consulted you. it could not have been before. So the consultative note was prepared after my meeting with Mzinyati.
So then you departed on your further introduction meetings as head of the SCCU. Where did you go to on the Tuesday?
I'm not so sure whether I started in Bloemfontein. I think I must have started in Durban. Then my last meeting was to be on the 8th of December in Bloemfontein, because it was when I was in Bloemfontein on the 8th of December that I received a call from Zinyati that he has been approached by Advocate Breitenbach, that they don't agree with my decision in the matter. Then I told him, unfortunately, I'm not in the office today. I'm in Bloemfontein. Let's rather schedule a meeting for the next day. And then we did, and then we met the next day.
And you also received an email, I believe, from Advocate Mzinyati.
Yes, I think I received that email when I came back to the office on the 8th in the morning. I must have read that email either before our meeting with Mzinyati, I can't remember now, or after the meeting with Mzinyati. I think it must have been after that.
So then who attended the meeting of the 9th, and where did it take place?
The meeting of the 9th took place in my office in VGM building. Present was myself, Advocate Breitenbach, and Advocate Mzinyati, the three of us.
And then just take us through the meeting and what occurred.
The first thing, or one of the things that happened in the meeting was indeed that they do not agree with the meeting. I do not know who spoke first, but Mr. Mzinyati said he had a meeting with Advocate Breitenbach, and they don't agree with my decision that the charges must be withdrawn. Then I said, gentlemen, unfortunately,
Is Breitenbach a gentleman?
Chairperson, I'm very sorry for that. I said to my colleagues,
I think okay, never mind.
Colleagues, that note was just a preliminary note, because when I came back, I thought...
When you say note, you mean the letter?
The consultative note, the letter, because it's titled consultative note. Yeah.
You directed it to Mzinyati, isn't it?
I directed that
to both of them?
To Mzinyati and copied Advocate Breitenbach. Now that you are here, let's rather sit down. Let us go through the evidence in the matter, because I did not go much into the merits of the case at that point in time. Then we went to the merits of the matter. We discussed the matter. My initial view was that, colleagues, I think we've got to be very sensitive here. We must know that we are not dealing with your normal environment. You are dealing with a security environment. And as we understand, as I understand the situation, it's not as easy as dealing your normal PFMA, public finance management regime. There's a specific regime that applies here. You need access to all information and documentation that you might require for background information and for purposes of advancing your investigation. The problem here, amongst others, is that these transactions are conducted in the name of front companies. We do not know how these were recorded, what information was behind this transaction or that transaction. Problem is that you need that information before you go to, it was after we understood the fact, as I've mentioned, that the problem here you're sitting with is that Mr. General Mdluli is not implicated. Is not. In the fraud case, he is not implicated. This 90,000 we're talking about, in terms of the shortfall that he was supposed to pay, all those transactions were done by his co-accused. I think at some point, I recall in the discussions, we might have to consider, if our investigation does not lead, we might have to consider using the co-accused against him. Those were parts of the discussions. Now, with regard to corruption, for example, because there were allegations of corruption in relation to the 50,000, it was said, by mere of the fact that there's a loan of 50,000 that was granted to General Mdluli, that's sufficient for corruption. I said, guys, it cannot be. Let's look at the law that deals with that aspect. The section concerned is Section 10 of the Prevention and Combating of Corrupt Activities Act, number 12 of 2012. That law deals with unauthorized gratification. If we have to prove an unauthorized gratification, that allegation on its own kicks in certain processes. By mere fact that there was that gratification, it means certain processes kick in, like, for example, exemption. Because as an employee, if you are doing your work, you receive a gratification from the person you render service to. You must either have been granted permission by your employer. It may well be that you were granted permission, or it may well be that you were exempted from that permission. So, do we have evidence of those exemptions, of those permissions? Do we have evidence of those exemptions? It may well be that in terms of your employment contracts, like all other senior members, you are required to disclose that business, those financial interest. But we know as a fact, in the crime intelligence, let's say Secret Service environment, it's not something that we can just pick up and phone somebody and say, because they operate in terms of a different regime. So you need that information even before you formulate an allegation. You cannot formulate an allegation of corruption without that information. That information is information as the basis on which you can start to say, at least because I know this person was supposed to disclose. I have been given access to his file. He has not disclosed. At least that's an indicator now that something is wrong. You've got something. But here, we don't have that evidence at all. So those were the issues that we discussed during that meeting. To the extent, I recall very vividly, Advocate Breitenbach, because, sorry, Chairperson, before I go there, because I said, my view, looking into the law around this, there are only limited number of people who can have access to that kind of information. It is either the IG, the Inspector General, or the Auditor General. Advocate Breitenbach even suggested, let's ask for a forensic audit report. That would help us so that we can determine. I said that's a good idea. We need to do that. Then thereafter, after that, it was a lengthy discussion, as Advocate Mzinyade says in his affidavit. It was extensive. We came to the conclusion that the matter must be withdrawn provisionally, number one. Number two, that Advocate Breitenbach is requested to ask the police to continue with the investigation with the assistance of the Inspector General. Number three, we agreed that once the investigations were finalized, Advocate Breitenbach can re-enroll the case. I recall during that meeting, she even requested a permission to say, Lawrance, can I immediately, as soon as these things are done, re-enroll the case? I said, you don't need permission from me. Carry on. As soon as you are done with whatever needs to be done in this matter, you don't have to come back to me. Just do what is necessary. So the meeting took a decision or agreed on those steps going forward. So in a sense, that was the decision of the meeting of the 9th of December 2011.
Sorry, can I just get clarity on something you said earlier? I just need to understand there's somewhere where I'm missing a bit of information. You say after you had consulted with Mzinyati, the consultative sort of meeting of the 5th, you had done your consultative note, which you say is was a preliminary sort of note, but then you also said at the same time, when you were preparing that, you believe that you had also possibly asked your secretary to write a letter to the attorneys of General Mdluli. But I'm trying to understand the preliminary note. What was then in the letter to the attorneys of General Mdluli?
Chairperson, the letter to the attorneys of General Mdluli would have been, it's just that I don't know whether I have access to that any longer, would have been, I've considered your representations. I've come to the conclusion that charges would be withdrawn. That could have been a very short paragraph letter. It could not have been longer than a paragraph. Responding with reference to your representation received on a particular date, I advise as follows that I've considered your representations, and this is the decision that I have. That would have been the letter.
So then the decision of the provisional withdrawal could not have been on the 9th of after the meeting, or on the meeting of the 9th of December, if a letter like that had already been sent out to the attorneys?
Yes, Chairperson, that was what was the reason for the debate on the 9th, because we don't agree with your decision. Then I had to come to their view. We had to agree that instead of withdrawing the matter as we did in my letter, it was sort of a retraction of that position to say, let's agree on this following step. The decision now would be to withdraw the matter provisionally.
Proceed.
I'm not sure. Do you want to take a break now? Are you happy to go on?
Go on, Chairperson. Let's carry on.
I think this time we can carry on. Thank you. He says so. We can proceed then. Thank you.
Thank you, ma'am. So the matter was set down for the 14th of December, if I remember correctly.
That is correct, Chairperson.
And at that stage, the matter was then withdrawn by the prosecutor, postponed or withdrawn provisionally by the prosecutor.
The matter was provisionally withdrawn on that date, Chairperson.
Now, we've had some debate about the use of the word withdrawn in respect of Section 6 of the Act, as to what does it mean when a matter is withdrawn. You remember the debate that was here about?
I recall that, Chairperson.
Okay, so what do you understand when a case is withdrawn? What do you understand that to mean?
When a matter is withdrawn, it is withdrawn. What it means is that should the police continue with their investigation and find new evidence, that matter could be reinstated at any time. It is not dead.
So even when you said to the attorneys acting for Mdluli the matter was withdrawn, it was not dead?
The matter, if you withdraw a matter, as soon as new information that could not have been there at the time, the matter comes back at any time. The matter does not die because it was withdrawn provisionally or because it was withdrawn whatever.
Now, just to perhaps assist the panel and myself, what was the difference then between the 5th letter of withdrawal and the agreement on the 9th? Was there any difference in law?
There was no difference in law at all between those decisions, between those withdrawals.
It's just that the decision that you took on the 5th and conveyed to the attorneys was done by yourself without the agreement of the other parties.
The difference is exactly that I did not have the agreement of the other party, hence the agreement that we had on the 9th.
To your knowledge, has General Mdluli ever been prosecuted on these fraud and corruption charges?
Chairperson, to my knowledge, up to now, General Mdluli has not been prosecuted on those corruption charges.
You were, in fact, your involvement with the Mdluli prosecution in any way whatsoever ended in 2014, is that correct?
Chairperson, my involvement with the Mdluli matter ended in 2014, to be exact. It was July 2014, after I submitted my last report on the matter to then NTPP, Mr. Ngasana, on the status of the investigation of the matter. That report of July 2014 was based, it was a consolidation of about 8 reports from various prosecutors who have been dealing with this matter since 2012, who came to the conclusion that as at that point in time, there is no way, based on the evidence, that we can take this matter to court. That matter was still unprosecutable as at that date. I was removed thereafter from having anything to do with the case in 2014.
So for almost 5 years, you've had nothing further to do with the matter?
For 5 years, as you are saying, I had nothing to do with the matter.
Just to clarify something else, because it's also been suggested that you did this as a favor towards General Mdluli. Do you know General Mdluli? Have you ever met him? Is he a friend of yours? What's the position?
Unfortunately, I know General Mdluli, like reading about him in the newspapers, seeing him on TV. I don't know him at a personal level. I've never had any conversation, either personally or over the phone, with him at any point in time.
So those people who accuse you of acting male fide because you wish to assist him, what is your response to that?
My response is that when I make a decision, I don't look at the nature or rather at the type of person. I do my decision based on the facts and the law. Whether you are Mdluli, whether I were anybody else, I have no reason to favor Mdluli. I have no reason to favor anybody when I take my decision. The fact that this person might not, at a particular point in time, might be hated, so to say, must not influence my decision. The nature of the person, the type of crime, must not come to that. What's important, bring the evidence. Let's apply the law. To the extent that you bring evidence, then we'll take the case. As long as you don't, unfortunately.
You say you were removed from the case, and was that during Advocate Ngasana's time?
Chairperson, it was
Mr.
during
Nxasana's
it was during Mr. Nxasana's time in 2014, July 2014.
Okay, thank you.
Just while we're there, how many national directors of public prosecutors have you worked under? Can you even remember?
Yeah, I worked under the first one until the last one. I don't know, Mr. Ngcuka, I worked under Mr. Ngcuka, I worked under Mr. Piccoli, Dr. Ramaide as an acting NDPP, Mr. Piccoli, Advocate Piccoli, Mr. Miche, I worked under Mr. Advocate Simelani, under Advocate Jiba, under Mr. Nxasana, under Advocate Abrams. Yes, about 8, both full or acting.
Then we got to, so after the matter was drawn on the 14th of December, it appears that Advocate Bradenbach did in fact involve the Inspector General of Intelligence, because there was a report that you later received, or a letter that you later received via General Dramat. Do you recall that?
I recall receiving that letter from Advocate Breitenbach by around about 26, if I'm correct, of March 2012.
And that is the letter where, as an annexure to General Dramat's letter, there was this report from Inspector General saying that they don't investigate matters and that they believe that you should reinstate the prosecution of General Mdluli. You recall that?
Yes, Chairperson, I do recall that. And let me just say, I was a bit taken aback by that letter from the Inspector General. The reason is a simple one. The contents of that letter did not accord with my discussions with the legal advisor to the Inspector General. On the 20th, if I recall, I don't know how I was
The
called.
20th of March, just
Sorry, 20th of March, 2012. I've been to the office of the Inspector General, and I sat in discussions with the legal advisor to the Inspector General. And I initially refused. I wanted to refuse because I could not understand why should I go to the Inspector General. But I think I was persuaded by then acting Commissioner of Police, Lieutenant General Mkhwanazi. Please go and listen to what she is going to, or what the Inspector General is going to say. Then reluctantly, I went there. She did not disclose to me that she has already written a letter to the NPA a day before my visit, because now we sat and discussed the matter. And I told her my position with regard to the matter. More importantly, that we still don't have evidence in the matter as far as Mdluli is concerned that links him to the crime, other than the allegation that the 50,000 rands could possibly be a gratification. But we discussed the matter. I took her through the matter intensively as well. It became clear to me when I had a discussion with her that this information I was giving her was new to her. She did not know that that is the position. But in any event, I told the Inspector General, the reason I said this matter must go to you is a simple one. I said it must go to you because in terms of your law, you are best suited in terms of access to documents. Immediately she jumped to say, we don't do criminal investigation. I said, no, that's not what I'm saying. I know you don't do criminal investigations, but you do your own investigations, your internal investigation. The important thing, as I read your legislation, you have no restrictions. You can kick the door. You don't need a warrant except, and things like that. In terms of a certain section 7.7C capital A of the Intelligence Oversight legislation. She listened to me and then said, look, Advocate Mrwebi, indeed, there is that provision in the law. But our position now is becoming different because in line with international best practice, we want to move away from anything to do with investigations. We want to be focused merely on oversight. But I said, there's the law. Yes, there is. She said, yes, there is a provision in the law. She even said, we are in the process of amending the legislation to provide exactly for that, so that there is a distinction, a differentiation between oversight functions and functions that may involve investigations. But I said to the inspector, as far as I am aware, you have an investigation that you are currently seized with. She considered that indeed we have an investigation that we currently have. But the impression I got, she said we have an investigation, but the position that we have taken is that we want to move away from that position now. And then I said, the point is that in this case, we have problems that it's easier and quicker with you, because you are not going to investigate for criminal purposes. You are going to investigate for your internal purposes, because you are in charge of the secret services, and then give that information to the police or suggest whatever. After some discussions, I got a sense that, she would have preferred that if we keep the matter on the roll. I said, no. This thing came up with Advocate Breitenbach to say, Lawrence, why can't we keep the matter on the roll? And I disputed that. I said, we can't. When we say we know there is no case, I cannot be party to that, because to me that would be an abuse of process. I'm here and I exercise oversight over the functions of my colleagues. I supervise them. I must ensure compliance with the law, the constitution, and otherwise, to me, that would be acting contrary to the law. So we left on that, said I'm not prepared to do that. Now, when I read the letter later on, I said, maybe the reason why she said I must keep the case is maybe because she had already written a letter, but she never disclosed that to me. So we left on that note, said I'm not going to do that, and I left.
You do respond to the letter of the Inspector General a little while later, but before that, on the 1st of April, you had a meeting with General Dramat. Do you recall that? You had a meeting with General Dramat.
Sorry,
I
you said something
think it was on the 1st of April. Was that before you wrote the letter to him, or after you wrote the letter to him?
If I recall, the letter that I wrote to General Dramat was dated the 30th
of March.
March,
Yes.
2012. After I wrote that letter, I became a bit concerned with my language in that letter. And I felt a bit of remorse. When I read it again, I said, this language is too strong. The reason for that is because I know General Dramat. I've interacted with him I said this language is not suited for General Dramat. Let me rather humble myself. Let me make an appointment to go and meet him the next day. The purpose of meeting him was to apologize for my language, because I felt the language was not called for. You know, it was... So I managed to secure an appointment for the next day, fortunately, the 1st of April. My first... Should I go?
Yes, continue the meeting with,
Yes.
with General Dramat.
Yes, my first issue when I arrived in his offices in Silverton is a house. I knew that house to be a house that used to belong to Mr. McCarthy, you know, when we had the Scorpion. So I was familiar with so we sat in a boardroom, two of us. First thing was to extend my apology and to explain the context, how to say, one of the things I was a bit angered that my prosecutors would take a letter from you and come and deliver that letter to me. One thing I forgot to mention was that when that letter was delivered to me on the 26th of March by Advocate Breitenbach, I think he was together with Advocate Ferreira. There was sort of an ultimatum that was given to me. When are you going to take a decision in this matter? And then I looked at her. What now? What's happening? And then when I said, Advocate Breitenbach, I am going to give consideration to this matter. Leave it to me. One of the things that also sort of angered me, what are you going to do with the media backlash? I said, who's going to give this information to the media? So I was a bit angry after that. That's why after I wrote that letter, I felt, let me go back to General Dramat and go and apologize. Because I also outlined that background to him as well, to say this is the context under which I wrote, I'm coming to apologize to you. He's a very humble gentleman. I know him personally. I still respect him today. And after that, we went into general talks, you know, before we went to general talks, you know, he mentioned, in fact, I mentioned the problems I have with regard to the case. What I explained, what we agreed with the with Advocate Mzinyati and Advocate Breitenbach on the 9th, and my meeting with the Inspector General, we had those discussions. And General Dramat, without me prompting, stated to me that, you know, Advocate Mrwebi, the problem is that the Auditor General looked into this account and did not find any fault with it. That would be the difficulty in the matter. I recall saying to him, yes, that could be the difficulty, but maybe the reason that he or she did not pick up anything is because maybe the Auditor General did not zoom to this particular transaction. If, for example, he can be requested to zoom into that transaction, maybe he will find something. Then after that, we engaged into some general discussions. And he gave me his background. I did not know that he was a cadre in the Umkhonto weSizwe. He told me about his underground activities when he was there. So what Mdluli is doing, associating himself with conspiracies about his position and things like that, it does not sit well with him. I said, generally, in any event, you know, I saw those allegations in his representations, but my attitude was that they don't make sense. What's important, we have to look at the facts. you know, and we had general discussions after that, and then I left his office.
Madam Chair, it would be convenient to take the lunch adjournment now. We can just then move on to the next issue. I just need to find some documentations in the sky or in the air or wherever it is.
Just dropped from the air or the sky or the cloud. It's in the drop.
Try and keep our feet on the ground. Thank you, ma'am.
Can we take a break? We will take a lunch break now and come back within an hour. Thank you. Promptly. An hour?
She said we've got problems, but let's ask.
Does Advocate Rip foresee a problem finishing this afternoon?
Okay, let's adjourn.